それではご紹介させていただきます。裁判官役はデリー高等裁判所、ヤシュワント・バルマ裁判官。原告代理人役はアダルシュ・ラマヌジャン法律事務所、アダルシュ・ラマヌジャン弁護士でございます。そして被告代理人役はサイクリシュナー&アソシエイツ、サイクリシュナー・ラジャゴパール弁護士でございます。それではよろしくお願いいたします。
Good afternoon. I call the court in session. Just to briefly put things in perspective, these hearings are for considering the grant of a temporary injunction pending the main suit. That is a practice which is permissible under Order 39 of the Code. There are two other postulates that we have borne in mind. One which is there in the mock case itself of the placement of the product in country B, and there being no dispute that the defendant's product is manufactured by using up the core tubes. We have also proceeded on the premise that the statutory structure in country A and country B is identical. May I now call Mr. Ramanujan to commence arguments on behalf of the plaintiff.
May it please your Lordship, appearing for the plaintiff in the matter, your Lordship has two issues to decide today in my application for interim injunction. Issue number one is whether the provision in the patent statute, section 107, capital A, subclause B, stipulates the doctrine of international exhaustion. Issue number two, if issue one is answered in the affirmative, is whether the import into country A of the defendant's product, which comprises replaced packaging items, is protected under this defense of international exhaustion. Your Lordship has the section extracted before your Lordship. I will not therefore repeat the entire section. However, your Lordship would note that under the statute, the exemption for so-called parallel imports, which the defendant attempts to argue, is only applicable if the defendant is authorized under the law. The plaintiff's submission is that the word law, as used in this section, can only mean our country's law. In the facts of the case, your Lordships will note that neither my licensee in country B, nor the defendant's subsidiary in country B, nor in fact the defendant is authorized under our law to exploit the patent in our country. Beneficial to us, your Lordship, is a judgment of a coordinate bench of this Honorable Court in the judgment of Sotofin, passed in 2022. This judgment is directly on point. The extract is before your Lordships to read. Nevertheless, to focus on the important aspect of this judgment, it clearly holds that the word law in the section is only the laws of our country and not that of the foreign country. The basis of this judgment is the fact that patents are always territorial in nature. Holding otherwise would imply some kind of an international patent which does not exist in law today. Each patentee can divide up the rights for each country differently. And therefore, in my humble submission, this judgment covers the point directly. The rebuttal of the defendant appears to be the reliance of another judgment called Kapil Vadava in 2013, which in my humble submission does not apply for 4 reasons. Reason number one, both orders are interim orders and not binding on this honorable court. But between the two, Sotofin is the judgment that is under the Patents Act, whereas the other judgment, Kapil Wadhwa, is under the Trademarks Act. Therefore, Sotofin is more relevant to consider. Second, the statutory provision in the Trademarks Act, which is extracted for your Lordship's consumption, is distinctly worded from that of the Patents Act. So the interpretation of the word market in the Trademarks Act is irrelevant because that phrase does not appear in the Patents Act. The third reason is because the judgment in Sotofin directly corresponds to the understanding of patent rights that has been in place in the United Kingdom for several decades. By reference is given to a 1974 English judgment, which is directly on point on similar facts. And since our law was initially drafted based on the English law, it is my submission that Sotofin therefore gives the correct proposition of law. And finally, my lords, whereas Kapil Wadhwa is currently under appeal before the Supreme Court, though the Supreme Court is yet to issue a final judgment in the matter, there is a cloud attached to the validity of the propositions in Kapil Wadhwa. The other contention of the defendant appears to be that parallel importation and international exhaustion applies because the legislative history behind the provision of the Patents Act suggests to that effect. There are 4 reasons in my humble submission that they do not apply to the facts of the case. 1, the so-called statement that is associated with the bill that entered the parliament when the law was enacted is actually silent on what is the interpretation of the term law. It does not specify whether it is our country's laws or foreign laws. Second, there is only an obscure reference to the word parallel imports in this legislative material and nothing more. Thirdly, the Supreme Court has held that ultimately all these are secondary references and your lordships will ultimately have to see the statutory provision as it stands in its plain and ordinary meaning. Therefore, in my humble submission, issue 1 should be in my favor and parallel importation or international exhaustion ought not to apply. Without prejudice to my arguments on issue 1, if your lordships were to assume that international exhaustion applies in this case, I would still submit that there is a situation of modification by the defendant and therefore they are not entitled to the exception. In this, I have 2 arguments. Your lordships might consider this as argument 2A and argument 2B. In argument 2A, my humble submission is that the statute specifically says that the import must be from a person who is authorized by law to produce and sell, whereas in the present case, the defendants do not have the authorization to produce. The second argument, 2B, is that the section only provides a safe harbor for the patented article and not an infringing article. Your lordships, the argument 2A focuses on the presence of the word produce and sell and is normally considered conjunctive in statutory interpretation. And if your lordships takes a view of the legislative history of this provision, originally the law in 2002 was anybody who is authorized to sell or distribute was sufficient. In 2005, the Parliament amended this provision to specifically insert the phrase produce and sell or distribute. So to the extent that the defendant or its subsidiary is not authorized to produce the product, the defense will not apply. This concludes my argument number 2A. Argument 2B, your lordships might consider the specific flowchart. Lordships will note that in my case, the patented article comprises 2 components, a core tube and a packaging sheet. The patented article is a combination of both components. Neither component alone is my invention because my claim comprises both components. So when my licensee manufactures the product, he manufactures both components together. When the consumer uses it, he is using both components together. But at the point of the defendant's subsidiary's collection, only part of the patented article is being collected. Only the core tube is being collected. That is not the patented article. When Turtle winds new packaging paper on it, then they make a new patented article by combining both elements of the claimed invention. My humble submission, therefore, is at the point in time that Turtle receives the core tube, it is not receiving the patented article, but by the time it exports the product, it is making an infringing article. To hold otherwise would imply a grave error in my humble submission, because the purpose behind exhaustion as a principle is to entitle the user or the recipient of the product to use and alienate the property as it deems fit. The purpose is not to enable third parties to make commercial money out of that product. Moreover, the patent statute is a complete code. Therefore, in my humble submission, unless the Parliament intervenes, this honorable court should not read new limitations such as the right to repair or the right to modify into the statute. With this, I conclude my submission. I am grateful for the opportunity to present my case.
I call Mr. Ramanujan to address submissions on behalf of the plaintiff, of the defendant.
The first issue, my lords, is whether the Indian position, as far as Indian patent law is concerned, prescribes or adopts the principle of international exhaustion. Now, intellectual property, my lords, residing in a product would at some point of time exhaust. Now, the question of whether this exhaustion is international or domestic is or would be articulated in the domestic law in question, which under this which in this case is the Patents Act 1970. Now, in my respectful submission, Section 107A of the Patents Act provides two very important and compelling clues as to whether the doctrine of international exhaustion applies or not. And this important clue is in the form of the use of the word importation in the section. This obviously means that what the section is referring to is a context of parallel imports, where a product is imported from one country to the other. Therefore, very clearly postulating an international exhaustion doctrine. Second, if my lords would look at the comparison between Section 107A as it stood prior to the 2005 amendment and post the 2005 amendment, what becomes clear is that it is no longer necessary or relevant for the patentee to authorize the distribution of production of the product. What this means, my lords, is that the intent of the patentee is no longer relevant under our law. And consequently, regardless of whether the patentee intended that the product will be reused or resold, is of no consequence at all. Thus, from a reading of Section 107A, it is apparent that the importation of a patented product is allowed so long as it is lawfully acquired. That is the only requirement. Further, the authorization of the patentee for such importation is no longer required. Now, the following facts, my lords, are not disputed. That the patentee, that the defendant, has been importing and selling genuine core tubes in country A, that is India, which have been procured from the users who had purchased the same from the plaintiff's authorized reseller. That the patent claim that is, i.e., C1 to C3, claims C1 to C3, is restricted to the aspect of a core tube having magnets which are detectable by the rotational angle sensors on the plaintiff's packaging device. These elements, that is, the core tube and the magnets, have not been modified in any manner by the defendant. And this, my lords, is a very crucial aspect of this case, in that the essential elements of the claimed invention are in no way emulated or replicated by the defendant in this case. And all that the defendant is doing is using fresh packaging material or sheets on an already used core tube. Now, my lords, I would like to cite for my lords' consideration a case which I believe comes very close on facts to the case that we have in hand. And this is the impression products case, where what was involved in this case was a situation where the defendant, Lexmark, sold refilled toner cartridges of the plaintiff after buying empty cartridges from customers of the plaintiff. And the finding of the US Supreme Court in this regard is extremely instructive. The Supreme Court held that Impression's primary argument was that Lexmark exhausted its patent rights upon the first sale of the product. The court further held that Lexmark cannot bring a patent infringement suit against Impression products to enforce the single-use, no resale provision accompanying its return program cartridges. Once sold, the return program cartridges passed outside of the patent monopoly, and whatever rights Lexmark retained are a matter of the contracts which is with its purchasers and not the patent law. Now, my lords, one important fulcrum of this case is whether the defendant is merely refurbishing the product or repairing the product or making the invention. As my lords are aware, under Section 48 of the Patents Act, the making of the invention is an essential ingredient. It is my respectful submission that all that is happening in this case is a mere refurbishment. And in this regard, there are two judgments which are extremely instructive. One is the Calidad case, and the other is the Schultz case. But for paucity of time, I would restrict my arguments, my oral arguments, to the Calidad case alone. In the Calidad case, my lords, a very interesting situation arose. This is a case involving Epson cartridges, where the plaintiff cartridges were designed as one-time use cartridges. The plaintiff did not envisage that these cartridges could be reused. What the defendant did, my lords, was to modify these cartridges in such a way that these cartridges were capable of reuse. And the question therefore arose whether, as to the modification of these cartridges by these defendants and the subsequent resale of them amounted to infringement. If I may just read just one crucial, enlightening paragraph as far as this judgment is concerned. The modifications done by 9-Star were as follows. In order that the cartridges may be used again, they must be refilled with ink. A needle is used to create a small hole in the side of the cartridge. Replacement ink is injected through the injection part and the outlet hole through which the ink was originally disposed are resealed using thin plastic and heat. The information at the memory chip is modified to indicate that the ink is not exhausted, either by rewriting the information on the memory chip or replacing the chip with a generic memory chip. The court further went on to hold that the wide scope given to the alterations to a purchased product which improve the usefulness of it is evident from a decision of the Supreme Court of the United States, which was discussed in Hewlett-Packard. In that case, the purchaser resized or relocated 6 of the 35 elements of a patented fish canning machine so that the machine could pack fish into smaller cans. The Supreme Court held that the purchaser had merely adapted the old machine to a related use. The expectations of SECO, the plaintiff, or the original purchasers as to the limited functionality of the cartridges are not relevant to the question of infringement. When all of 9-Star's modifications to each of the categories of cartridges were completed, what remained were the original Epson cartridges with some modifications which enable their reuse. The modifications did not involve the replication of parts and features of the invention claimed. There were no true manufacture or construction of a cartridge which embodied the features of the patent claim. My lords, if I may pause here for a moment, this is exactly the situation we have at hand, where no element of the claimed invention is being emulated or replicated in this case. The modifications to the original Epson cartridges were consistent with the exercise of rights of an owner to alter an article, to improve its usefulness, and to enable its reuse. Both English and United States authorities accept the prolonging of life of a product to be within an owner's rights of use of a patented product, regardless of whether it is said to be something done which is closer to repair rather than making it. In conclusion, my lords, 2 clear propositions emerge. One, that India follows the doctrine of international exhaustion. 2, in the specific facts of this case, all that is being done is an addition of a packaging sheet to the core tube without in any way altering the core tube or replicating the core tube itself. And in this view of the matter, my lords, I would urge this court to dismiss the injunction application sought by the plaintiff. That's all, my lords.
Thank you. For the sake of brevity, and since the statutory provisions have already been referred to, I'll take the liberty of skipping the first 4-5 slides which have been referred to by both counsels. So essentially, on hearing arguments from respective sides, we essentially called upon to answer 2 basic questions. A, of course, the applicability of international exhaustion, and the second would be the argument of repair and make which has been made. But sticking to the provision which prevails in country A, we find on a comparison of section 48 and 107A, that 107AB has been clearly structured to remove certain actions and create an exception from what would otherwise fall within the scope of infringement under 48. As was cited, there were 2 decisions. One decision which was cited insofar as courts in India are concerned. So we have Kapil Wadhwa, which deals with the expression lawfully acquired, and as it appears in the trademarks statute. Following Kapil Wadhwa, there is another decision rendered by our court, and that is in Philip Morris, which too had held that once products are lawfully acquired as per laws of that country, sale of those products in country A would not constitute an infringement. From an international perspective, the counsel for the defendant has referred to the decision in Lexmark. And there are certain very important observations which appear in Lexmark, as would be evident from the passages that we have on our screen. Exhaustion essentially deals with the extinguishment of the exclusionary power. And it goes back to the principles underlying the first sale doctrine. They also say that the power to restrict the purchaser's freedom to sell or otherwise dispose of, that is not something which can be controlled by a patentee. If you will see the second passage, which appears on the screen, they also hold that differentiating between a patent exhaustion and first sale doctrines would make little theoretical or practical sense. Calidad is an instructive decision rendered by the Australian High Court, and that too significantly observes that the principle of exhaustion and the right of the purchaser to use flows from the laws of personal property. And once a chattel has been obtained, the owner has an absolute right to use or dispose it of. It further observes that the patentee's monopoly rights are exhausted on sale. Calidad also refers to decisions rendered by the US Supreme Court on the subject. But there are two aspects which we find would measure notice, and these are the principles of what would be the right of a purchaser notwithstanding exhaustion being urged. In United Wire, the House of Lords very pertinently observes that there is no implied license or exhaustion of rights can have no part to play. The sale of a patented article cannot confer an implied license to make. Same was the view expressed by the Australian High Court in Calidad. The plaintiff would refer to a decision rendered by our court in Sotofin. Sotofin may not be persuasive for more than one reason. Firstly, as we notice, it fails to notice previous binding precedents which had been rendered on the subject. Kapil Vadava was in fact rendered by a bench of a larger quorum. So even if it be a judgment rendered on an interim application, it clearly bound the learned judge who rendered decision in Sotofin. Philip Morris was a judgment rendered by a coordinate bench. In my humble opinion, Sotofin falters at more than one place. It essentially seeks to resurrect a position which existed prior to amendment. It no longer, the provision as it stands today, no longer requires authorization of the patentee. Sotofin seems to advocate a completely opposite position. Similarly, the reference to the provision itself being confined only to Indian law is again contrary to two previous decisions. And as I find that the defendant appears to be correct when they contend that the word importation as appearing in the provision must be accorded some meaning. And surely when we speak of importation, it has to be the laws of more than one nation. it would thus appear to be correct to hold that so far as the Indian position is concerned, the principles of international exhaustion do clearly appear to have been adopted. As we find from the various decisions that have been referred to in the opinion which has been circulated, any fetters that you impose on a patentee, be it obtaining consent or authorization, would clearly amount to extending monopoly rights, which the patentee had willfully chosen to give up. We would be of the opinion that the exhaustion doctrine, in fact, seeks to strike the right balance between the monopoly right which can be exercised by the patentee and the individual property rights which are exercisable by a purchaser. The legislature in India thus clearly appears to have adopted those principles, as is evident also from the parliamentary debates and the committee reports which have been referred to by the defendant. The judgments that we have had an occasion to review, rendered across different jurisdictions, appear to place only two express limitations. One is, of course, the prohibition against making, and the other is the existence of an express negative covenant or stipulation imposed by the patentee himself. In the present case, undisputedly, the plaintiff's product was placed in the market in Japan. The court would thus be of the view that once it had been so placed in the market, the plaintiff extinguished its monopoly right on the product by virtue of the exhaustion principle. This still, however, leaves us to consider whether the defendant has made the patented product. In dealing with issue 2, the court has identified 6 principal issues on the basis of which it would be inclined to hold in favor of the defendant. As Mr. Rajagopal rightly argued, the core tube had not been worked on. The core tube remained untouched. It would also have little utility once the packaging sheet had itself finished. All that the defendant appears to have done is to extend the life of use of that product. We would thus be of the opinion that the usage of the used up core tube would not entail replication of a core or essential element of the invention. In any case, there was no inventive element claimed on the packaging sheet which was wound around the roll cob. For the aforesaid reasons, the court would be inclined to dismiss the prayer for injunction in the interim. However, and before concluding, it would be pertinent to refer to a note of caution. Courts should avoid considering or answering the question of whether it was a making by first laying emphasis on whether there was repair. As most statutes do, they frown upon the making. In most statutes, there is no reference to repair per se. The doctrines of impermissible reconstruction and permissible repair are those which have been evolved through judgments. It is therefore but imperative and necessary that before adopting a line advocated in any of the decisions, one must have a clear bearing on the facts. It is this perhaps which led the House of Lords as well as the UK High Court to refer to issues of fact and degree. On an overall consideration of the aforesaid, I would be of the opinion that prima facie the plaintiff has failed to make out a case for infringement, and I would therefore dismiss the application for interim injunction at this stage. This would conclude the trial from our side.
以上でインドチームによる模擬裁判を終了いたします。どうぞ大きな拍手でお送りください。ご登壇の皆様ありがとうございました。